Yes, Your Honor, the counsel for appellant is ready.
All right, sir. Mr. Goldsmith, would you like to reserve any time for rebuttal?
Yes, Your Honor, I would like to reserve 5 minutes.
Sir, you'll have that. You may begin.
Thank you. May it please the court, I represent the appellants. My name is John Goldsmith from the Trenum Law Firm. I represent the appellants who are also the plaintiffs below, who are all Florida companies who were sued in Maryland for ERISA pension withdrawal liability based on the liability of a different company called Florida Glass, which had filed bankruptcy 8 years ago, because the plaintiffs in this case have the same ownership as the appellants. The lawsuit was brought by the plaintiffs for abuse of process against the pension fund and its lawyers for improperly using the Maryland lawsuit to extort money from the plaintiffs that was not owed by the plaintiffs or sought in the Maryland lawsuit. Specifically, the defendants demanded an interim withdrawal liability deposit payment by the plaintiffs by letter in the amount of $518,000 plus interest on November 30th, stating that if the deposit was not made within the 60-day cure period, that the pension plan would bring suit. Instead, 3 weeks before the pension period ended, they've instead filed a lawsuit. And even after the plaintiffs paid the $518,000 plus interest by the cure period, the defendants refused to dismiss the lawsuit and instead demanded additional payments that were not owed and were not sought in the Maryland litigation.
I don't see where your pleadings allege that there was any impropriety with filing the claim within the bankruptcy and also issuing the demand for Florida Glass, correct? I don't see where
we are not.
You haven't alleged that they failed to comply with ERISA, correct?
We are not alleging that. That's correct.
Okay, so let me get the playing field then, because in your response to the motion to dismiss, 6 months after the complaint, you dropped the defamation action against the corporate defendants and their attorneys, correct?
That's correct. That was a mistake for them to have been sued.
Okay, so that means that there were no false representations by the corporate defendants or their attorneys that would be the basis for sending a demand letter. Therefore, the demand letter wasn't sent on your false pretenses. But you also contend in your complaint that you don't owe withdrawal liability. So if ERISA exclusively addresses and controls the determination of withdrawal liability, how to determine it, whether it's presumed to be correct if you don't initiate arbitration, how is a state court to adjudicate this without complete reliance on ERISA?
Because we are not arguing that we don't owe money for withdrawal liability. That's not it at all.
In your complaint in paragraph 39, you clearly allege it saying that the appellee intimidated your client to pay grossly overinflated withdrawal liability that they do not owe. That is a sworn pleading. That was before this state court. Also, your counterclaim in the Maryland action seeks a debt relief as to whether you owe it. Your client owes it. So
correct.
If we leave it in state court, it appears that the state court would still have to wait for the federal court to determine whether the fund's determination of a withdrawal liability is correct or not.
Right. And Your Honor, this is the reason why paragraph 39, I think you also have to look at it in conjunction with paragraph 51 of the complaint. Paragraph 51 of the complaint says, even though API and Fenwal paid the $518,000 plus interest by the January 30th deadline, IPPF, Tucker, and Pepicelli refused to dismiss the lawsuit and instead made another demand for payments of additional monies that they were aware are not owing and threatened to use the Maryland lawsuit as a basis to obtain additional monies. But the argument is that what they're seeking is not withdrawal liability. And I agree that paragraph 39 is inartfully drafted, which is
But
why.
doesn't ERISA exclusively control and determine what withdrawal liability is?
Yes,
How can the state court adjudicate that without interpreting this federal statute?
because what we're arguing, Your Honor, is not that they're seeking more withdrawal liability than they're entitled to. The withdrawal liability they are seeking, it was set forth in their proof of claim. That they filed in the bankruptcy in the Florida class place. It is set forth in the November 30th demand letter, and it's set forth in the lawsuit in the Maryland case. But that's not what they've been demanding from us. They've been demanding money in addition to what was demanded in the Maryland lawsuit. That's the extortion. They're essentially saying we're going to, even though you're making the payments. So under the withdrawal liability plan, you can make payments. You're required to make payments, and you make them on a monthly basis. And even though my client is making those payments while we're contesting the withdrawal liability, they're continuing to pursue the Maryland claim unless we pay monies in addition to what they're seeking in the Maryland litigation.
You mean in addition to the minimum amount that's required to be paid prior to an adjudication of what the entire amount is?
Yes, but not only that, they're seeking more. They're seeking additional money from us that is not being sought in the lawsuit, either on an interim or on a final basis. That's what our lawsuit's about.
How will the state court determine that that is in excess of the ERISA withdrawal amount liability? Without referring to ERISA.
They don't need to look at ERISA at all. All they need to do is look at the proof of claim filed in the bankruptcy and look at the November 30th demand letter and look at the lawsuit filed in Maryland. And that sets forth the amount of money they're seeking. And we've paid all of those monies into the to the pension fund. It's basically a deposit to make sure that those payments are made until the court can make the determination. But I
don't see that in your complaint that you've made all the payments. I don't see that at all.
Well, the reason is because we filed this lawsuit after we made the first interim payment.
Okay, but you're claiming extortion, you're claiming it's premature, and you're also complaining that it's incorrect, but yet you paid it.
We paid it because no, that's not true.
What's the legal significance of you paying something that you claim that you do not owe?
We are required while we are contesting the withdrawal liability in Maryland, we are required to pay the payments that are demanded by the pension fund, and we have paid those.
According to what law?
According to the ERISA withdrawal liability. That's basically our ticket to stay in court, is that we have to make these interim payments, and we are. But that's not what we're suing for here. What we're suing for here is they're demanding additional monies. In other words, they wouldn't need to continue to sue us if we're making the withdrawal liabilities, and we can contest those withdrawal liabilities in a different forum, but they're keeping the lawsuit alive. Which required discovery, briefing, all sorts of things that we had to do, requiring us to pay a lot of additional money because they're demanding that we make payments in addition to the withdrawal liability. And that's what paragraph 51 alleges. That's what paragraph 52 alleges. We say that they're using the Maryland lawsuit to improperly extort money from plaintiffs to pay amounts that the defendants knew were not and are not owed. They're not, it's not monies that they're seeking in the Maryland lawsuit. They're seeking additional monies because they know it's going to be expensive for us to continue to litigate the case in Maryland. That's a classic.
What is
process claim.
premised on what? They're seeking what you call additional monies, on what basis? They premise that entitlement to on what?
They have not, that's the whole point. They have not articulated the basis for seeking this additional money. And so when we allege they filed the lawsuit 3 weeks before the cure period, that's simply to provide a background for the action that the pension fund is taking. They are attempting to force us to defend a lawsuit that where we've agreed to make and have been making the payments. And so what's happened here now.
You would agree that if the federal court rules in your favor on your deck action and gives you relief that you do not owe this additional amount, this is moot.
It's
This is
not
moot. Your counterclaim seeks deck action, declaratory relief that you do not owe it. You do not
Correct.
owe. Well, first of all, you claim that you don't owe withdrawal liability at all.
correct.
But also the federal court is in the best position to determine whether they are indeed seeking more than they're legally entitled to, correct?
Yes, but that's the point, Your Honor. They're demanding money from my clients that they're not seeking in the Maryland litigation. That's the problem. They're demanding money in the Maryland litigation because they're demanding money they're not seeking in the Maryland litigation, and they're saying, if you don't pay us this money that we're not even seeking in the Maryland litigation, that we're going to continue to pursue the Maryland litigation and you're going to have to defend it.
So this
That's-
money, you're confident that when opposing counsel gets up there, she's gonna. What do you think she's gonna say about why they think that they're entitled to that money?
Well, I mean, from their brief, they contend that all we're seeking is that we're saying we don't owe withdrawal liability, but that is
No.
not.
Yeah, what this additional money, yeah, why don't you contend with what the opposing party says they entitles them to it?
Well, the opposing party can't say that they're entitled to withdrawal liability of more than what they sought in the lawsuit in Maryland. But that's exactly what they've demanded.
What are they basing that entitlement to what more than they saw it in the Maryland?
That is the point, Your Honor. They're not. They're demanding an extortionate payment. They demanded an extortionate payment, and if not, we're going to be forced to defend and have been forced to defend a very expensive Maryland lawsuit. And again, this is in addition to the money sought in the Maryland case.
Mr. Goldsmith, subsection 1401 says that if you don't initiate arbitration, any determination made by the plan sponsor is presumed correct. You did not initiate arbitration. You're indicating that you relied upon counsel's representations, whatever, whether that's a legal defense or not. But you didn't initiate arbitration within the window of time provided by ERISA. Therefore, it says it is presumed to be correct, and it's your burden to disprove or rebut. What do you say to that?
Your Honor, those are issues for the Maryland court, and
It's an issue here too, because you're
It's not.
arguing before a state court that they're demanding more than they're entitled to.
correct.
How is the state court going to determine that without relying on ERISA?
They don't need to look at, well, first, as the court as the courts have said in a number of cases, including the Supreme Court in Mackey, even if you have to rely on even if you have to look at ERISA, even if the plan will have a significant financial impact on ERISA, that doesn't mean that you have ERISA preemption. You don't have either complete or defensive preemption. But the point that I'm making, Your Honor, is that what they're seeking is set forth in the Maryland lawsuit. They're either, the Maryland court will determine
Maryland
whether,
lawsuit's not filed in this record, so I can't find it anywhere, so.
the
I didn't
lawsuit.
file it.
I believe that's correct.
And I do not have a transcript of the motion to dismiss hearing. Not saying I can't, we as a panel can't review that, but it would be helpful. You're at 15 minutes. Would you like to continue?
Let me just finish and then I'll stop. I think
Okay,
there are two cases that I think are important. One, the Mackey case that I said where the U.S. Supreme Court said lawsuits against ERISA plans for run-of-the-mill state law claims for unpaid rent, failure to pay creditors, or even torts committed by an ERISA plan are not preempted by ERISA, despite, quote, obviously affecting and involving ERISA plans and trustees. I also want to cite Judge Meisel's opinion in the district court that remanded the case back, where the court distinguished our case from the ERISA case in Maryland. And the court specifically said that even if the state court must address, and this is on page 12 of her opinion, some aspect of the ERISA dispute, the state's court's decision will not stand as binding precedent for any current or future withdrawal liability claim, because the resolution of defendants pending ERISA suit is not an essential element of plaintiff's abuse of process claim. To succeed on their abuse of process claim, plaintiffs must prove that process was used for an immediate purpose other than for what it was designed, rather than the result for which it was contended. By contrast, the defendant's complaint in the Maryland suit alleges violations of the withdrawal liability. And the court goes on to say, resolving the Maryland suit will require the district court to determine whether plaintiffs improperly withdrew from the pension fund. This inquiry is distinct from an abuse of process analysis, which will evaluate the defendant's motive for bringing the Maryland suit, not the merits of the defendant's claim. And as a result of that, the court said no state court will adjudicate an ERISA claim. And the district court respectfully was correct, and the trial court in state disagreed and entered its order, and we respectfully requested that it be reversed.
all right, so you have 3.5 minutes.
Thank you.
Thank you. Counsel, are you going to divide your time in any way?
Yeah, yes, Your Honor. So I'm Ramya Ravindran. I represent the pension fund.
All right, good morning.
Good morning. May it please the court. My co-counsel, Mr. Brown, and I are dividing our time by issue. So I'm planning to use approximately 15 minutes to address ERISA preemption, and Mr. Brown will then address the state law issues. So I want to touch upon two key points that came up in the appellant's presentation, which is the quote, demands for additional payment that are the basis of the abusive process claim. And I also want to address the remand order. But just taking a step back, what this lawsuit is it seeks to impose tort liability on an ERISA plan for actions they engaged in their role as an ERISA plan to pursue payments that are a creation of ERISA under a process that's governed by ERISA. So this case represents a classic example of ERISA preemption, and the trial court properly dismissed the complaint on that ground. Now, both in their brief and in their presentation today, the plaintiffs have asserted that the, quote, demand for additional payments that form the basis of their abusive process claim is unrelated to withdrawal liability. But that is not what the complaint says. The complaint is very clear on this point, on what the basis, the factual basis of their abusive process claim, and on what it clearly identifies what these additional payments are. And as Judge Sleet pointed out, that is set forth in paragraph 39 of the complaint. That is not inartfully pleaded. It's actually very clear. It says that the alleged abusive process, the misuse of the Maryland ERISA litigation that's pending between these parties, is that the fund defendants have continued their tirade of demanding, quote, the rest of the withdrawal liability from plaintiffs using the prematurely filed Maryland lawsuit as a basis to intimidate plaintiffs to continue making payments for, quote, the grossly overinflated withdrawal liability debt that they do not owe. So in paragraph 51 of the complaint that the plaintiffs pointed to makes that same allegation. They omitted the term withdrawal liability, but they said additional monies that the fund defendants are well aware are not owed, and that we're using the, quote, frivolous Maryland lawsuit to obtain additional monies that are not due. But paragraph 39 identifies what those additional demands and additional payments or additional monies are. They are the rest of the withdrawal liability and the, quote, overinflated withdrawal liability debt. So looking at the way ERISA structures withdrawal liability is paid in installments. It's a monthly payment schedule, which is what it is here. That's acknowledged in paragraph 28 of the complaint, that the withdrawal liability payments are to be paid in monthly installments. And when one of those installment payments is missed, ERISA provides a cause of action to the pension fund to sue for collection, which is what happened here. That's the Maryland ERISA litigation. And ERISA also provides that in a collection action, the pension fund is entitled to recover not just the principal amount of the payment, but also interest, liquidated damages, and attorney's fees, which are mandatory under the statute. The statute says if the fund prevails in a collection action, the court shall award attorney's fees. So that's the recovery that the pension fund is seeking. The complaint that was filed in Maryland is it is in the record. It's at let's see.
Page 81 is one
Yes,
place.
correct. Yeah, thank you. And so that's the collection action. But remember, the collection action seeks to recover delinquent payments, so past due payments on that withdrawal liability installment schedule. There is still an obligation to continue making the future payments on that withdrawal liability schedule. Those are the interim payments, and that is what is stated in paragraph 39 of the complaint about the additional demands, the rest of the withdrawal liability payments, the rest of the withdrawal liability debt. Those are the remaining withdrawal liability payments. That is what the pension fund has demanded, as well as the consequences of being delinquent on your past payments, which is interest, mandatory liquidated damages, mandatory attorney's fees that are provided under the statute. We
And
understand.
in order to adjudicate all these issues, is there a state regulatory scheme that a state court can rely upon?
No, because to determine whether or not these payments are not owed, which is the allegation, you have to first determine what is owed. And that what is owed is what ERISA gives the pension fund the right to collect: past due delinquent payments, the future interim withdrawal liability payments that came due after the filing of the Maryland lawsuit. As each month passes, another payment becomes due, and if it's not paid, then there's interest, and then there's the statutory liquidated damages. This is in section 1132G of illicit 29 USC 1132G. There is statutory liquidated damages and mandatory attorney's fees if a collection action has to be filed. And so these are all amounts that the pension fund is entitled to recover. The only additional payments or additional demand that has been identified in the complaint is the rest of the withdrawal liability payments and the overinflated withdrawal liability debt. So the complaint makes very clear that the basis of the abuse of process claim is a demand for additional withdrawal liability. It is a dispute over whether or not they owe what the pension fund believes is owed under the withdrawal liability procedures of ERISA. And that's what distinguishes this case from the cases that the plaintiffs cited in their reply brief about non-preemption. The only relationship that exists between these parties here is their ERISA relationship, because the plaintiffs assert that the pension fund asserts, and in Maryland, the plaintiff asserts that the appellants here are part of what's called a control group, which is a statutory defined term in ERISA that says that the pension fund is entitled to collect withdrawal liability, not just from the specific departing employer, who is Florida Glass here, but all entities that are part of the same control group. And there's a test for that in the statute, has to do with common ownership between the various parties. And that's the basis of the pension fund's demand. We believe that the plaintiffs are all part of the same control group and therefore are jointly and severally liable for these amounts. And yes, that's disputed, and that's what's being litigated. That the Maryland federal court will decide whether we're right or not about that. But in terms of ERISA preemption, and you can look at the cases we cite in our brief, which is the 4th DCA's decision in Bertoni, or the 11th Circuit's decision in Englehart, or you can look at cases that the plaintiffs have cited in their brief, the 11th Circuit decision in Moorstein, the 5th Circuit decision in Memorial Hospital. They all say the same thing. ERISA, that when in determining whether a state law claim relates to, which is the test in the statute, an employee benefit plan for preemption, the most important factor is, does it affect the relations between principal ERISA entities as such, in their capacity as ERISA entities? And that is what we have here. We have principal ERISA entities, we have a pension plan, we have control group employers, and we have the attorneys representing an ERISA plan in an ERISA action. And the basis for the state law claim, as the court described it in the Englehart case, the impetus for the state law claim is an action taken by the defendant in its capacity as an ERISA plan. And that's what happened here. The pension fund, as an ERISA plan, is exercising rights that it believes it's entitled to under ERISA to collect, withdraw, to make demands for additional payments of the interim withdrawal liability payments, to seek to recover not just the principal payment, but interest, mandatory liquidated damages, mandatory attorney's fees, which the pension fund believes it's entitled to under ERISA. There's no separate non-ERISA relationship between these parties, as there was in the cases that the plaintiffs have cited, where there was employer, employee, creditor, debtor, landlord, tenant, I think director, shareholder, company
Your opponent
officer.
never sought to amend.
What's that? Excuse me?
Your opponent never sought to amend the pleadings.
That is correct. That is correct.
So your argument is it's preemption regardless.
It is preemption, and it's preemption as a matter of law and dismissal. So it's not just dismissal was appropriate, but dismissal with prejudice was appropriate.
Well, an amendment would have been futile, is what you're saying.
Amendment would have been futile, even if that issue had not been waived before this court, because it's not that there's a pleading deficiency here. It is that the facts affirmatively pled in the complaint establish as a matter of law the preemption issue.
Oh, that's what the trial court ruled, correct?
That is what the trial court dismissed with prejudice, correct, on preemption grounds. And so and then one last point I want to make, in terms of the remand order by the federal court here. So as the plaintiffs acknowledge in their brief, there are two types of ERISA preemption, which are unhelpfully both called preemption, unfortunately, but they are distinct doctrines. The first, complete preemption, that is a jurisdictional doctrine that transforms state law claims into federal claims, which is why the court, in the portion that was quoted by Mr. Goldsmith in his presentation, the court was looking at that the state court will not be adjudicating an ERISA claim. That's the test in terms of whether there is complete preemption. Are these state law claims really claims that could have been brought under ERISA Section 502 of ERISA? But that determines federal subject matter jurisdiction. That is distinct from defensive preemption, which is an affirmative defense that can be raised in state court to defeat state law claims. That is what the trial court decided this case on, defensive preemption. The federal court determined subject matter jurisdiction. It did not address, and of course could not have addressed, any other issues, including the affirmative defense of defensive preemption, because it found it lacked subject matter jurisdiction. And again, the Bertone case from the 4th DCA dealt with this similar situation. And as it explained, the appropriate course of action there is, if complete preemption is lacking, then you remand to the state court, leaving it to the state court to determine the issue of defensive preemption. And that's what the state court here did. It applied the doctrine of defensive preemption, which comes from the statutory preemption provision in ERISA, section 1144, that preempts any and all state law claims that relate to an employee benefit plan. And again, as I had said earlier, the test in this context, when you're dealing with state law claims as opposed to a challenge to a state statute, which was the issue in the Mackey case that the plaintiffs cite, when you're looking at whether state law claims relate to an employee benefit plan, the critical factor is, does it affect the relations between principal ERISA entities as such? That is the case here, and therefore the trial court's decision should be affirmed. I'll hand it over to Mr. Brown.
Spending 12.5 minutes. Good morning, Mr. Brown.
Good morning, Your Honor. I'm going to try to be brief. I'm not sure how many minutes were left we have.
You have 7.5.
I don't think I'll need all of that, but please let me know if I go past that. My point is, part of the argument today is to touch on issues that are really more in the nature of tipsy coachman issues. We did allege or plead below, argue in our motion to dismiss, that abuse of process claim was not stated, failed to state a claim because of the way it was argued in the complaint that it attacked. Abuse of process is distinguished from malicious prosecution in that, whereas malicious prosecution argues that there's bad faith in the complaint that is filed, an abuse of process claim requires a, quoting the 2nd DCA in Peckins versus Kay, requires a showing of willful intentional misuse of the process for some wrongful and unlawful object or collateral purpose. The writ or process must be used in a manner or for which a purpose for which it is not by law intended. And what the abuse of process cases go on to say, that if a party is only attempting to obtain through a case what it seeks and alleges in the complaint, is not engaging in abuse of process. Abuse of process would be something such as doing some type of collateral act. For example, in Florida, there's cases where a party in a routine dispute filed a lis pendens that was clearly not appropriate. Courts have held that's an abuse of process because that is a separate procedural act. As my colleague demonstrated, that despite the attempts of the plaintiffs today to essentially amend their complaint before this court and argue that paragraph 51 says something other than what it actually says, it is absolutely true that paragraph 39, which alleges that the wrongful act was seeking inflated or additional withdrawal liability, directly implicates the ERISA claim that's involved in the case. But even if we accept the attempt to amend the complaint today and argue that paragraph 51 is talking about something other than withdrawal liability, the plaintiff hasn't identified what that is, and they certainly haven't identified that it's something outside of ERISA. Now, since we're going a little beyond the face of the pleading in terms of the plaintiff's argument to the court, I would simply point out that the Maryland complaint filed by the fund is in the record in this case. On record page 81, you can see the complaint starts before that. It's not lengthy, but the key part is on record page 81, where the complaint contains its prayer for relief. The prayer for relief, part 1, all past and future withdrawal liability payments under the payment schedule. We've talked about what that is. That's the interim payment schedule, plus all collateral damages available under ERISA citations. Ms. Ravindran explains that is things like liquidated damages, interest, and attorney's fees, which are statutory and mandatory in such a case. B, sought the entire accelerated amount of withdrawal liability if the plaintiffs did not cure the default that was delinquency that was underway. Keep in mind, at the time this case was filed, the plaintiffs were overdue 8 monthly payments. It is true that they have a cure period before acceleration, but they have not alleged in the Maryland complaint that in their counterclaim that that the Maryland case filed by the fund was premature. What the plaintiffs are attempting to do here as part of their abuse of process claim is argue things that either they did not argue in the Maryland case and could have, or things that they have argued in the Maryland case. That goes to the second issue I want to talk about in terms of the abusive process that I think will demonstrate that this is just nothing but a collateral attack on the Maryland case. If you look at paragraph 50 in the plaintiff's complaint, it alleges 6 ways in which the Maryland complaint is allegedly frivolous. You'll note, Your Honor, that every one of them touches on the merits, either factually or legally, of the ERISA withdrawal liability claim. So the whole substantive basis in paragraph 51 is a collateral attack on ERISA issues being litigated in Maryland. And I want to provide one irony is that in this complaint here, they allege that our complaint was frivolous in Maryland because that the plaintiffs here were not under common control. In their counterclaim in Maryland, they acknowledged they were under common control. So not only is this relitigating the Maryland issues in large part, it's also contradicting the plaintiff's position in Maryland with respect to at least one issue. As a practical matter, one issue is still being litigated in the Maryland case, but it's the issue of statute of limitations, and that's going to determine who wins the case. If the plaintiffs here win the statute of limitations issue, then they'll probably win the Maryland case. If they don't, then the Maryland case will continue. But again, these are issues that are appropriately decided by the Maryland court and not this court because of ERISA preemption and because here there's no ability to state an abusive process claim when everything that the plaintiffs are relying on are actions that touch on either the substance of ERISA or the specific relief our client is seeking under ERISA. We've also raised, and I'll leave to the court to review that if it thinks it needs to, we've raised the litigation privilege issue. The plaintiff argued that that's an issue for summary judgment, and in some circumstances it may be. But the Latham investment case, which we cite, points out it can be raised in a motion to dismiss, where on the face of the complaint, litigation privilege is clearly implicated. If you look at paragraph 50, in terms of the things that were supposedly wrongful, and paragraph 51, everything that's being alleged to have occurred in Maryland is part of the Maryland litigation. The filing of the complaint, the maintenance of the complaint due to additional relief that the plaintiffs, that the fund plaintiffs in Maryland believe they are entitled to, and which the Maryland court will determine. This court would have no need to do that. Based on that, the litigation privilege clearly applies on the face of the complaint here simply because there is no action that has been taken either outside of the litigation or outside of the mandatory pre-litigation process that is mandated by ERISA. The last question.
Surprisingly, you have taken your time. I'll give you 30 seconds to wrap up.
Okay, sorry. This was literally the last thing I was going to point out. You asked if there's a state regulatory scheme to address these issues. Not only is there not, but by the federal scheme that we are relying on is clearly by law the only scheme that is permissible. The preemption language is very clear that this is exclusively a federal process. Thank you, Your Honor.
Thank you. Okay, Mr. Goldsmith, you have 3.5 minutes, sir.
Thank you, Your Honor. So I want to point out something very important in the argument made by my opposing counsel. She said that the reason why Judge Mizell remanded the case, and this is correct, because the federal court ruled that in deciding our case that we filed in state court, that the court will not be deciding ERISA. That's exactly.
Let me point something out to you that she may have missed, because her opinion clearly says that the plaintiff's abuse of process claim does not contest withdrawal liability. That is a big oversight by her, because that is incorrect, and you have admitted that you allege that emphatically.
Okay,
That's
but
all
my,
she said. She mentioned defensive preemption 3 times in a description. But she also said that your complaint for abuse of process does not contest withdrawal liability. That's an error. That is a huge error.
well,
Go ahead.
Your Honor, let me address that. We do mention the issues of withdrawal liability. And
Under oath.
well, it's not under oath. It's not a sworn
Your
pleading.
complaint is sworn to,
It's not a sworn
but you
pleading.
do not owe it.
Well, Your Honor, first, the complaint is not a sworn pleading. It's an unsworn complaint. First,
We're supposed to take it as true.
that's correct. But my point is,
Okay.
and this is my point, is that yes, we allege a lot of background information, but it's why the court ruled, and you're correct. We did not have a transcript of the hearing because both sides ordered a court reporter. We called, we found out both sides ordered it, and mistakenly we both canceled. So we didn't have a court reporter. But I can represent to the court that I requested, if the case is dismissed, that at least I should have leave to amend the defendant's
No,
argument
that's
against.
not in the record, sir.
It is not in the record.
At all.
It is not in the record, but
Something too. You never filed a motion for reconsideration or a motion for rehearing.
I did not do that.
I understand that. I've canceled court reporters by mistake too. I empathize with you. But we just can't take your representations as to what you did at a hearing.
I understand that, but my
You
point.
have 20 seconds.
Okay, I've got 2 points to make. Number one, notwithstanding that, the court should not have dismissed the case with prejudice on the first complaint. Secondly, I want to cite to the case that we cited in our brief, the Johnson versus Unum case, and in that case, there was the ERISA plan had done an investigation. They determined that fraud was committed. They submitted the complaint, and as a result of that, the person got arrested. And the court ruled that is not preempted by ERISA when they brought a malicious prosecution claim, even though it was everything that they did was in connection with an ERISA plan. And so that case is very close to this case. And at a minimum, we should be allowed to make clear that the amounts that we're seeking, that the amounts that they have been demanding are amounts that are not being demanded in the Maryland case. Because that's the basis.
Thank you.
Thank you,
Very
Your Honor.
well argued, very important case. Good job. Thank you very much. I wish you a good rest of the day.
Same to you. Thank you, Your Honor.
Thank you, Your Honor.
Yes, sir.